my colleagues, please.
Dave Barger also. All right, thank you. Welcome to everyone. Like the record showed, the board chair, Robert Walker, as well as the vice chair, Robert Cassidy, and attorney member Jay Rosas are each of them recused and will not be participating in this case. Attorney member Michael Tiger, who you see on the screen, is participating remotely via Zoom. We are here on exceptions to the hearing committee report from both respondent and disciplinary counsel. And it appears that the parties may discuss who will proceed first. Is that respondent?
Yes, we did.
You will have 20 minutes each, and I just want to ask then, Ms. Hoffman, would you like to reserve any of your time to respond?
Yes, and pursuant to advance agreement with Mr. Metzler, with the permission of the board, we'd like to take 12 minutes, for our opening and reserve 8 minutes for rebuttal. And with the permission of the board and with Mr. Metzler's gracious agreement ahead of time, my partner, David Barger, will handle the rebuttal, the 8-minute rebuttal. And we'll try to stick roughly to that time. We'll do the best we can.
Sure. You have gotten up your mic when you run out of time. So whenever you're ready, please proceed.
Thank you. May it please the board. My name is Adam Hoffinger, and together with my colleagues, we represent Jennifer Kirchhoff, the respondent. And we've taken exception to the report and recommendations of the hearing committee for 3 reasons. First, the Office of Disciplinary Counsel, ODC, did not prove by clear and convincing evidence that Jennifer Kirchhoff's decisions regarding discovery in the January 2017 riot cases were unreasonable. Second, because ODC failed to prove its case, it left a void that the hearing committee tried to fill, but with opinions, thoughts, and speculation, rather than the type of testimony and evidence that the due process that this board and this body and their rules requires. And finally, the sanctions imposed here on a highly regarded career prosecutor with an unblemished record was unduly harsh, unprecedented, and inconsistent with recent rulings of the Court of Appeals in similar cases involving prosecutors who were charged with misconduct. So first, under well-settled recent case law in the Court of Appeals, in order to prove that our client committed misconduct, ODC was required to prove by clear and convincing evidence that, and I quote from Dobby, a reasonable prosecutor would know that the withheld material, in this case, these are action camp videos of a community event prior to the riot, tended to negate guilt or mitigate the offense. I'm quoting from the case. ODC didn't do so. ODC called only 3 witnesses, defense lawyers from the case themselves, to say they would have wished that the prosecution had produced, in particular, the action camp videos.
Excuse me, counsel.
Please.
Before you get into further argument, in your brief, you didn't cite to any of the hearing committee's findings of facts, and it seems like you want us to somehow disregard the hearing committee's findings. So it's hard to understand where your position is coming from. Are you saying some of the findings were not founded or wasn't based on substantial evidence? But isn't this body, aren't we to take into consideration the hearing committee's findings of fact?
Absolutely. My recollection, I think my recollection is we certainly referred to the findings of fact. We agree with some and disagree with most. I think our point, and there are, look, we don't have the time, so I'm not going to answer, for example, unless you want me to. If you ask me about Project Veritas, or ask us about, for example, the other issues in which the committee did find in our favor, and we appreciate that, like the upper echelon and so on, we're absolutely ready to answer that. But we're focusing on what we believe is the primary holding based on the findings of fact. And our argument is that the findings of fact, frankly, were not based on the kinds of facts and evidence that ODC should have presented. So we haven't ignored those findings of fact. We just posit that those findings of fact were not sufficient because they were based on testimony, for example, that wasn't appropriate, that wasn't reliable, and there was an absence of the kind of evidence that proper findings of fact in law could have been made. So that's the gist of our argument. But thank you for asking. The witnesses.
Counsel, let me ask you, if I wanted to find out if a piece of withheld evidence is material, where's the best place to go? I would suggest certainly not the trial judge who's got a docket of over 1,000 cases and can't read things. So I've got to go to your client and to defense counsel, right? And then, so is that a credibility choice?
Well, in terms of withheld material, you would want to go to my client, and our client did testify. If you wanted to know whether it was material, the question is material to what? And I think the issue and the problem here, Mr. Tiger, is that what the defense lawyers testified to, the materiality that they testified to, and the definition of materiality and of Brady exculpatory material that they used was not Brady. Let me give you an example. Roy Austin testified, and I cross-examined, that he was asked, what's Brady material? And he said, quote, anything beneficial to the defense. That's not Brady. I have the case. I'm happy to read the language. I know you know it probably much better than I do. Sarah Croft, the other defense lawyer, said that the video should have been disclosed because she would have, in quote, hammered the jury with them. That's not Brady. That is perhaps what defense lawyers might like, but a defense lawyer wish list is not the same as Brady, and it certainly isn't the grounds for holding a prosecutor who's following the definitions of Brady as defined by the courts in deciding what to produce. So I think that's.
Let me just ask:
Sure.
would the withheld videos have been admissible in evidence under Federal Rule of Evidence 106, rule of completeness?
But that doesn't. I'm sorry. I misunderstand the question. That doesn't mean they're Brady.
No, maybe it does, and maybe it doesn't. The question is, would they have been admissible under the rule of completeness?
I'm not sure. I know what your question is. What the answer is? You say under the rule of completeness to what? First of all, the action camp videos were available. They were known to the defense counsel. They were able to cross-examine about them. Action camp itself was entirely known, so there was nothing secret about it. And now when you say the rule of completeness, again, my recollection from law school, and you know better than I do because you teach law school, but my recollection from law school, between the rule of completeness and the requirements of Brady, I think the rule of completeness tends to be a lesser evidentiary rule, whereas Brady, I think, is more mandatory. So I think under any circumstances, you know, the videos, and I'll jump to it because you've asked, watch them. There's nothing exculpatory on those videos. Those videos do not compare whatsoever to the kind of material that the three prior cases treated as exculpatory Brady material, or frankly, as anything that experienced lawyers think of in terms of Brady. It was a community event. There were two defendants seen briefly on them. There are some discussions about things like what to do when someone kicks a dog. There was nothing about these videos, or nothing on these videos, for example, that in any way questioned the veracity, for example, of a witness, the way that in Haynes and in Klein and in Dobby, the three court of appeals, the information withheld in those cases, in every instance involved, for example, a prior inconsistent statement of a witness. That's Brady. For example, a statement of a victim who said early when she was in the hospital, I didn't know who the shooter was. That's Brady. We don't have to argue about that. Nothing like that. Nothing like that here.
Not the same standard as Brady, right? We keep talking about materiality. That's not an element. 3.8
Well, as we read 3.8, and as the courts have read it, and as Dobby interprets it, for example, 3.8 does in fact run with Brady. I mean, that's precisely in those cases precisely interpret the interplay between 3.8 and Brady. And that's why we're here. I mean, I'm sorry, please.
Potentially exculpatory. And I think that the action camp videos, I mean, we've got Judge Warren, you know, in the underlying matter saying that it's exculpatory. I'm not sure any of the judges in the record, did they ever see the action camp videos?
Well, Judge Warren says he didn't see the action cam videos. It's not clear where the others, but let me say something about the Judge Warren opinion. What's important about the Judge Warren opinion, I think is missing from ODC's brief, is you have to look at Judge Warren's opinion as two pieces. Piece number one was initially, he was upset. And by the way, Ms. Kirkhoff wasn't there. He was upset. And he said, gee, I think that these are exculpatory, and he expressed concerns. He later clarified his holdings. And this is very important because he says, later, he says, I want to make it clear. Let me read from his decision. He said, I want to make it clear that the conduct was unintentional and it was not an attempt to make purposeful misrepresentations to the court. Well, you say based on the record in front of him and based on the. Well, actually, it was. All the transcripts were. In fact, ODC offered all of them in evidence. They were all in front of this. They're all in evidence here. Absolutely. I mean, Judge Moore, if Judge Moore wasn't in a position to make that decision. By the way, not only, this is important because ODC talks about, and unfortunately the hearing committee mentioned it also, talks about patterns of deceit and lies. None of the judges, these are judges who tried the cases, none of the judges, and who also ruled on the discovery, precisely the discovery battles that these three defense lawyer witnesses brought to this hearing committee. None of them found that Ms. Kirkhoff had committed deceit, lies, or anything intentional.
Your better argument, counsel, is that, you know, in the real world and not in hindsight that we have after a record that's about promoting these investigation of however many years. But in, you know, the moment, the respondent was managing, you know, a huge matter with 230 plus defendants, and it was proceeding at various stages in front of 3 different judges. And indeed, she had, you know, a mountain of evidence that she was trying to manage, and she was receiving some sort of varying direction from the bench about, you know, don't truck defense counsel. And that's the record. That looks to be a conversation about videotape from cell phones.
Absolutely. Let me take it even further. And you foreshadowed a portion of my argument. She was subject, I mean, under the circumstances and the conditions, she was also subject to strict and clear, well, it may not be in hindsight as clear as you might like it, but clearly there were limitations that the courts placed on her, not just the dump trunking, and I'm glad Your Honor mentioned that. You know, it's interesting, when she directed Ms. Kirkhoff not to dump truck, by that she meant, and it was understood that she was saying, don't give the defense everything, just focus on the ACB riot. She said that. And in fact, at that time, and this was before the hearing committee, Ms. Kirkhoff said, you know, I'm a little concerned that you're putting me in a Brady trick bag. And, you know, it sounds prescient now that we're standing here. So, you know, you asked why we're talking about Brady. It's sort of, it's not funny in a comical sense, but that's exactly what happened. Judge Morin also gave specific instructions. They kept talking about, we want you to take a middle ground. We don't want you to dump truck everything. So in the face of all of this,
The disrupt J20 wasn't the issue, but it's simply the capitalist block because I'm having trouble struggling with how that statement could even been made.
Well, I think it was both Leibovitz and Morin. I mean, she was instructed by both of them, you know.
It's funny, he sponsored the January 8 meeting. We have the video from that, right? That was a disrupt J20 event.
Well, I think the view of the courts, of the judges was, and they've said it, that J20 was on trial.
Understand what was the mindset that your client left with that sort of.
The mindset that she left with, I can explain it. I think you're explaining it to a certain extent. The mindset was, I'm doing the best I can. I am struggling. I'm the sole prosecutor in this case. This is a case with decisions made not by me. I'm basically on my own with a detective. I've got many, many defense lawyers. And, on the one hand, defense lawyers ask for everything. And on the other hand, she has judges who were saying, don't give them everything. And she was trying to balance all that. And in balancing that, when looking at something like these tapes, as compared to something like obviously exculpatory, like we have in the other cases, she did her very best to look at it and say, it's not ACB. The defendants are hardly on this at all. Petrohelis is on it for a moment. Weber's in and out of it for a moment. They're not talking about the kinds of things that happened actually at the riot itself. And by the way, yeah, it's sponsored by J20, and I've gotten instructions from the judges to keep J20 out of it. So given all of that, and with all of the other stuff that we're producing, and by the way, Judge Morin went out of his way to say that the government had produced a mountain of evidence in the case. So again, in terms of circumstances, when you put that together with the question of whether this was as clearly Brady as the ODC might suggest, I think the answer is very clear. And to go back to the point about what a reasonable prosecutor will do. Look, we made a point in our brief. We said, look, there were no former prosecutors. Now, we're not saying that it had to be a former prosecutor. Now, it's not a cosmic coincidence that in Klein, for example, in other cases, the witness is called by the government calls a prosecutor to testify that, gee, it would not have been reasonable to do this or it was reasonable to do it.
They're taking a look at the evidence that Ms. Haynes introduced based on, the ordinary course of her work. She had some supervisors, vetting the decision she was making about withholding the debrief statement that was in play in that case. And she had OPR, she had, I think, instances that she put into evidence of that being vetted within this attorney's office. And the court might read them saying, and give them paraphrasing coordinators, but that, we're not really bound by that. What the Haynes courts, I read them say, is that we're going to look at established case law, and we're going to look at the ADA guidelines as well to determine whether you've met that standard. That seems to suggest to me that ODC is not going to face the burden of putting an expert on the stand every time they have one of these 3.8 cases. I mean, this is a rule that was written for prosecutors.
Understood. We're not suggesting, by the way, I'm not suggesting that you have to put on a prosecutor. What we are suggesting is that they were required to prove their case with witnesses who actually were able to establish what a reasonable prosecutor would do. Three defense lawyers who had, three defense lawyers, and look, I don't want to. It may be relevant, but it may not be. What a defense lawyer thinks and wants when charged with a zealous representation of no one but his own client is not the same as having someone who is giving objective, reasonable testimony about what would be reasonable under the circumstances. And these three defense lawyers didn't. And here's the other thing: 6 AUSAs were on ODC's witness list. Now, I understand they're not required to call anybody, but it raises an interesting question. We were surprised when they called none of them. And the one former AUSA who we were able to find out about by fighting and asking for a memo of interview, Brittany Keel, actually said that she didn't think that Jennifer Kirchhoff had done anything wrong, and she had a very strong character. She didn't testify.
Mm.
But so, look, we're not asking for a bright line, but let's go back to this notion
It's
of,
hard when you say that the hearing committee like filled the gap with their own opinions and, feelings. And, but I was a hearing committee officer, and we hear these cases and we're trying to decide whether the respondent has met the standard of a reasonable lawyer.
let me make
That
it
happens
clear.
every day.
Let me make it clear. We're not actually criticizing the hearing committee. We're criticizing ODC.
No,
for-
no,
for
the hearing
getting-
committee was
putting the
in
hearing
your
committee
sights.
in a position where they had to, rather than rely on the type of evidence that you had in the other cases, Haynes, Dobby, et cetera, they had to go outside of the evidence. And it's interesting. I understand the notion of thinking, but and maybe I'm putting too much weight on this, but the hearing committee itself concluded by saying, we think. Now, again, in a case like this, where we're entitled to due process, we're entitled to have evidence upon which findings are made. I thought it was telling, and this is not a criticism. I don't think the hearing committee had a choice, because all they had in front of them were three defense lawyers who said, gee, we really would have wished to have it. We wished we'd had more. We would have done-
Xander seems to make that relevant. I mean, that seems to be relevant evidence under Xander.
It may be relevant, but it's not enough, we submit, to find her liable and subject her to the most unprecedented punitive sanctions ever visited on a prosecutor. And especially in a situation where the material is nothing like the material upon which sanctions, much less, were imposed in the three relevant cases.
Counsel,
So,
excuse me.
Please.
I'm struggling with her conduct, her actions in those three cases. It just seems like it's a pattern of intentional withholding of information. So I don't know how you square that with Judge Morin's instructions and her obligations. She still had Brady obligations. So explain to me why we should accept your argument that based on her caseload, that this is a complex case, that she had 238 defendants, why she should be absolved of her Brady obligation.
Well, let's talk a little bit about this notion, the notion of withholding of intention. You say that the intentional conduct. I suppose it's in the eye of the beholder to a certain extent. If you start with the proposition that her decisions were reasonable, in other words, her decision, if you start with the proposition that her decisions were unreasonable to withhold the tapes, and perhaps to withhold Project Veritas and some other things. The hearing committee ruled our way. I'm not fighting with them on that. But my point is if you start with the proposition that her decisions were reasonable based under the circumstances that we discussed, then the fact that she repeatedly takes that position, those positions which she believes are reasonable, doesn't turn them into lies or deceit. The only way you can see them as lies and deceit, if you start from the proposition and you essentially prejudge it by saying, listen, from the get-go, she should have turned over the tapes or anything else. And then you draw a conclusion by saying, and that's what ODC does, because we believe that she should have turned it over in the first instance. Therefore, every time she either doubled down or she took certain positions or she protected her decisions not to disclose, she was lying and she was repeating the deceit. But that's based on a prejudgment that we believe is wrong and not supported by the evidence. So again, it's the way you look at it. And one of our concerns in this case, and since you've asked, I must be frank, we have a concern about why this seems to be prejudged, why several years after these cases, ODC decided to bring this case when she was still a prosecutor in Utah. She was forced to resign as a result of the bringing of these charges. And when we look at this case in the light of Haynes, in the light of Dobby, in the light of Klein, in terms of the conduct, it is difficult for us to understand why she is being blamed as really in some ways the solitary decision maker and solely responsible for what we all concede was a complicated set of cases and Mr. Gilbertson, I appreciate you recognizing that this was, I mean, this was a Herculean task. One of the courts, I think, said this, that she was faced with. Why, after all this time, have we judged her as someone who's engaged in a pattern of deceit and should face the most serious sanction? And I think it's unfortunate, and I think it's unfair. And again, it may be based on things that we can argue in hindsight, and the hearing committee says we think now, we think in hindsight at this point. But what about at the time? What about looking at the time? Watch the video. Really, watch the video. I know Judge Moran didn't. That video, and looking at it, even if you don't look at it in light of the clear instructions she was getting from the judges and the position she was in, that is not, it's not a Brady, forget about Brady then. It is not a something.
Potentially exculpatory.
It's not.
Let me ask you about Project Veritas, though, as the source of the, video segments that the respondent did use in the first trial and was prepared to use in the later trials. What's your argument that that was not exculpatory? Because the way that played out, that led to the discovery of the action camp videos itself. So I feel like it's a textbook case of how, in a vacuum, you might not think it's exculpatory, but then, it's the type of information that led to the discovery of other evidence.
The issue with Project Veritas and Mr. Rosenzweig, I think, got this when he ruled
The dissent.
when he dissented. Excuse me. The issue with Project Veritas was the identity of the videographer. Now, again, you can't look at it in a vacuum. Let's look at it in context. Here's what happened. There was a videographer who worked for Project Veritas, who actually taped the meeting. We had an undercover officer, Officer Edelmeyer, who was there and watched everything and testified. The only issue about Veritas was the identity of the videographer, which has nothing to do with the testimony of Edelmeyer. It has nothing to do, there's nothing that the videographer could have said to impeach the credibility of Edelmeyer.
Is there an issue, though, in the trial with Edelmeyer really being able to provide a proper foundation for introducing that video? Because I think that he'd been edited out of the video, right? And that was something that your client decided to do. But when you saw the whole thing unedited, it was clear that he wasn't even present in the breakout meeting with the anti-capitalist bloc people.
Well, he testified that he was present through most of it. And by the way, whether he was present, now you're not talking about a question of authentication. So if you're suggesting that the videographer was needed to authenticate the tape, that's a different question, I submit, than whether it was Brady material. It should have been.
Well,
so
turns
you
out
and I are now arguing a different point, which I appreciate. I'm not going to argue with it, but it's a different point. It really is. The question is whether the identity of the videographer was Brady. Absolutely not. And Mr. Rosenzweig got it right on that. Look, I know I've gone over my time. I wonder. I would like to reserve some time for my. If you have more questions of me, please ask.
I just, you laid out 3 items at the outset that ODC did not prove that the discovery decisions that Ms. Kirchhoff made were unreasonable. Secondly, ODC's failure left a void that you believe the hearing committee inappropriately filled with its own view of the evidence. And you think that was some sort of due process issue there. And then finally, sanctions not being in accord with the similar cases. So, I mean, please, if you've got some additional points you want to make on those, go right ahead.
Please, with respect to how the hearing committee got it wrong, because I guess our point is this: the hearing committee tried to fill in where ODC failed, but it failed because it didn't have the proper evidence for it. And
is there an instance where they're relying on something outside the record?
Yes, actually.
Okay.
In fact, there's a section of the report, we didn't address it, but there's a section of the report that talks specifically about uncharged conduct.
Okay, but so that was conduct that was in the record but not charged, you believe?
Not that I believe, I'll get the
What's the
report out. and I'll
duty?
read it to you.
Does ODC have a duty to like charge every piece of evidence that might be consistent with the violations they're charging?
I guess my answer to that is, I don't know what ODC is required to do, but it was a little surprising to us that the hearing committee felt it needed to actually look at uncharged conduct. Under what circumstances does, and look, maybe I haven't been a hearing officer, but the fact that the hearing committee went out of its way to look at uncharged conduct that hadn't been charged, I think raises questions. You asked me whether they went outside the record. They voluntarily went outside the record. And again, that tends to support our concern that perhaps they were put in a position where they had to supplement the record with their thoughts, their speculations, and even look at some uncharged conduct in order to justify what was going to be the harshest penalty in the history of cases involving a prosecutor. So again, I'm speculating, and I apologize, but you asked my question, and it was surprising to me. I didn't expect to see that. The hearing committee got wrong in three ways, just very quickly. Number one, the only witness who testified about what a reasonable prosecutor would have done was our client herself. And she was cross-examined, but there were no witnesses who were called to rebut, what she said in terms of her belief that under the circumstances of the judge's rulings and everything else, she believed that what she was doing was reasonable, and what she withheld was pursuant to instructions to take the middle ground and not to dump
She testified to her own subjective belief under the circumstances.
I understand. I understand that, but
unlike in Haynes, I don't know that I saw on the record any instance where she came forward and said, and this decision, I actually vetted it with my superiors.
That's not
okay. Correct me, please. That's why we're here.
I must actually. She testified at length that her decisions, both discovery decisions, certainly the decision to bring the case, but that discovery decisions were vetted and discussed. She named supervisors specifically, like Tishner, who, by the way, was on the ODC's list, but they didn't call. Her decisions were vetted. Her decisions were reviewed. Her decisions were approved. By the way, just to go back so that it doesn't look like it was just her, just to give you an example, the tapes that we're talking about, she wasn't the only person who reviewed the tapes. One of the other AUSAs, Borchett, on their witness list, not called. He reviewed the tapes and found nothing relevant and no Brady material, along with Detective Pemberton. Detective Pemberton is not a prosecutor, I understand. But she was not flying alone. She didn't bring this case on her own. She didn't make these discovery decisions on her own. And there was extensive testimony from her. Now, was there
Excuse me. I'm sorry.
Sure. No, please.
Isn't she, I think I read in the record, but correct me if I'm wrong.
I'm sorry. Say that one more time.
I said, please correct me if I'm wrong. Wasn't she an expert in Brady? I thought I read that somewhere.
What?
Brady, like the rule.
Brady compliance. She conducted training on Brady in the office.
I'm sorry.
Well, she was a longtime prosecutor, and yes, she would, if she were to answer your question, she'd say, yes, I thought I had a pretty good idea what Brady was. And by the way, that's why I was confident, in part, in my own belief that the material that I was withholding was not Brady. I don't know. By the way, I don't know if she'd call herself an expert. I never know what that means. But clearly, she was a very experienced supervisor. No question about that. But the U.S. Attorney's Office is not a place where even experienced prosecutors make all the decisions. And there was extensive testimony by her about other prosecutors. For example, just to give an example, I mean, there were other prosecutors who were even in court. So during Judge Morin's first ruling, she wasn't even in court. She didn't even have an opportunity to contest what he was saying. There were other prosecutors involved in the case, other supervisors.
Why was that? Had she been withdrawn from the case at that point?
No, I think no, not at that moment. That moment, I think she was doing something else. There was a point in time later on, right? There was a point later on after that ruling that she was pulled back because of some concerns about what the court had said. But then Judge Morin later, some months later in the same year, on a motion for reconsideration, clarified his earlier decision, in which he was very clear in saying I don't think the government has been intentionally deceitful. I don't think the government has engaged in purposeful misrepresentation. Please.
Well, and you guys have 12 minutes reserved. So let me just ask each of my fellow board members if they have any other questions for you at this time before we hear from Mr. Metzler. And I'll
Yes,
start- but Mr.
yeah, I'm just want to ask you, you several times have talked about uncharged misconduct. Doesn't Federal Rule of Evidence 404B expressly permit introduction into evidence of uncharged misconduct when it bears on the issue of intent?
Now, ODC didn't provide any 404B evidence as far as I know. And in fact, the uncharged conduct that the hearing committee considered was not 404B evidence that had been offered by any prosecutor. It was uncharged evidence that the hearing committee itself took onto itself without the request of ODC to consider. And frankly, I don't know if it's gratuitously or voluntarily or on its own, decided to insert it in its opinion. So it's not a 404B situation. Let me make one more point. I appreciate.
No, and I just want to make sure though that my fellow board members have any questions.
Please,
Dr.
I'll wait for you.
The Haynes decision, which went on a 1 page of a 3-page letter, is different from editing videotapes that then get presented. I mean, it's the decision to edit, is it not?
I confess I'm not sure, and I apologize, I'm not sure I understand your question. I think with respect to the editing, the editing that was done in this case, and I don't know much about Haynes except what I read in the opinion, and I have it here. The editing that was done in this case was done with the intention of complying with the judge's instructions. For example, the judge's instructions to keep J20 out of it, the judge's instructions to take a middle ground. The judge's instructions at one point, one of the judges said, I don't want you to be giving over evidence of innocent persons. Now, you know, again, I don't want to get personal, but there are a number of folks here who've tried criminal cases. And in criminal cases, one of the frustrations of defense lawyers is that, and I was a prosecutor as well, but as a defense lawyer, one of the frustrations we have is that we get dump trucked, you know, and we get put in a room and it'll take you 3 months to find the needle in the haystack. That's what the judges were trying to ward against. And as a result, the prosecutor was under an understanding, a reasonable one, that she had to do whatever she could to both withhold and properly edit things that the judges wouldn't consider to be relevant and would consider to be dump trucking. Now, to go back to Mr. Gilbertson's point, you know, it's easier for us to go now, and we could go back and we could nitpick. And we could certainly say, gee, in hindsight, it would have been better if we turned over this and turned over that. But I know that's not the standard that this board is applying. And especially in this kind of case, you know, and the court certainly realized this. In this kind of case, it's virtually impossible to get it right 100% of the time. The question is, what was her intent and were her efforts reasonable? And the record and the evidence and her testimony demonstrates absolutely that it was reasonable. Can I stand here and say it was perfect in every instance? No. And we can sit back and say in hindsight, gee, we could have done this and we could have done that. But we all know that that's not the standard.
And let me ask Carolyn, if you have any questions?
At this time, I do not. Thank you for the opportunity.
With your indulgence, I'm sorry, I apologize.
There's one left.
You hadn't
Leslie.
asked that. I'm so sorry, Ms. Spiegel. I
All right.
apologize.
Yes.
Sorry, I actually just had 2 questions. The first was you had mentioned 3 points the hearing committee got wrong. I think you mentioned that the only witness was the respondent as the question of the reasonable prosecutor. I wondered if you could quickly run through the other 2, just to, if you haven't already covered those. You
Sorry, say that. I'm sorry, I didn't hear the last part.
Sorry, you had mentioned that there were 3 ways you disagreed with the hearing committees. As you said, the filling in of gaps. You mentioned first that the only witness as to the reasonable prosecutor standard was the respondent, and that I was going to ask, was there other evidence in the record that would support that, or would your position be that the only evidence as to what a reasonable prosecutor would or wouldn't have known was respondent's testimony? Or is
No, we're not suggesting that it was just hers at all. Oh, no. I mean, I'm happy to go back over it, but I think we've covered, I think the points, to give you 3 points quickly.
that was my other question, was I think
well,
you had mentioned.
Well, I'll do it very quickly. Our point about how the hearing committee got it wrong. Number one, in light of the judge's rulings, her decisions were reasonable. And we've talked about her rulings. I can go back, the rulings, but I go back over them. The no dump trucking, don't focus on J20 and so on. Number two, it was reasonable for her to believe that the action camp videos were not exculpatory. I've touched on that, but I'll give it to you succinctly. It was a community event. It wasn't a planning event, by the way. It wasn't part of the planning for the ACB march at all. ACB was not even discussed. That's the anti-capital block. It wasn't even discussed on the video. And by the way, there's nothing on the tapes that would tend to exculpate under Brady or 3.8 willing participants in a violent black bloc riot, which is what we ultimately had. So
What we have though is a charge of a conspiring to riot, which I think once we appreciate the charge of conspiracy, that the universe of exculpatory evidence tends to really balloon, right? So a number of these defendants are before the court, and there's no evidence that they conducted any sort of rioting activity. They're there solely on allegations that they planned to riot. And isn't that what makes Action Camp relevant? Because, it did have something to do with all of the activities that Disrupt J20 was planning for the inauguration.
well,
And ACB was one of those things.
I respectfully disagree in
Okay.
the following sense. If you watch the tape, well, first of all, let's separate that. It's true. Look, there were 260, 80 people charged. And, the result, we know what the results were. I mean, there were virtually no convictions, some pleas. Yes, ultimately there were some people who had not been involved in the violent activities. There were also a number of people who were. There was a car set on fire. There were stores destroyed. So, again, going back and putting ourselves in the shoes, as you suggested before, at the time, here's a prosecutor trying to weigh out. I've got some people who were definitely involved directly in violent activities. I've got others who maybe ultimately might not have been, but the event itself was and turned out to be overall was not a peaceful event.
No.
And I'd be happy
Went off the
to
rails.
Okay, so in terms of looking at overall, and if you look at it that way, the relevance, if at all, of something like this community event shrinks by comparison.
Did Ms. Kirchhoff's conduct that's at issue in this case, did that play a role in the decision by the U.S. Attorney's Office to dismiss all the charges ultimately?
Not that I know of. Not that I know of. And by the way, number one, that's never been communicated to her. Number two, she has not been disciplined. I can't go too far, and I think some of you'll know why, but she has not been disciplined, was not disciplined. She was not fired. In fact, and we've been criticized for this, she moved to Utah with her family, in part because of the threats in this case, the bomb threats and things like that. That's where she lives now, which unfortunately was reported in a lawyer's blog, so it's out. She was an assistant U.S. attorney for a number of years in Utah when in the U.S. Attorney's Office when ODC charged her 6 or 7 years after the event. It caused many defense lawyers to move to reopen her cases, even though it had nothing to do with this case and so on. And under those circumstances, she ended up resigning. She was never fired. She was never fired, and she was not disciplined. I did want to cover my last third points that you asked me, and thank you for inviting me. And thank you also for indulging me. I probably shouldn't admit this, but I've obviously argued cases before. I haven't done a lot of these. So thank you, and I haven't done as many as Mr. Fox well, I knew years ago when we called ourselves white collar lawyers. There is a final point as to why they got it wrong. There was no prejudice to the defense from the withholding of the action camp videos. The existence of action camp was known. I'm sorry, the action camp videos were known to the defendants and their counsel. And
How?
well, first of all, action camp was in the notes of Officer Edelmeyer. And those notes were produced in pretrial discovery.
So they knew the action camp meetings had happened.
Number one. Number two, the action camp information was publicly available. Everyone knew about it. And number three, again, one of the Mr. Weber, Casey Weber, who was represented by April Downs at one of the cases that went to trial, actually attended action camp. And April Downs testified at the hearing. And she testified that she never cross-examined anyone about action camp. Again, I'm not going to, I don't think it's fair to speculate why. I could, if you want me to, I'll give you an answer. I mean, these
The
are,
video was merely duplicative of other evidence that was available.
and again, these April Downs, these are very experienced defense lawyers. April Downs has tried many, many cases. So the fact that she didn't cross-examine on that, it's a fair inference that there was a reason why. Let me just finish up quickly, and that's this. The sanctions, I think we've talked about. And one of the things I didn't get to talk about is one of the things that it appeared that the hearing committee didn't consider were the mitigating factors and at least give sufficient weight to them. Now, number one, her unblemished record and reputation. And the Dobby case specifically says you shouldn't publish, Haynes says it's not appropriate to suspend a longtime prosecutor for, and I quote, a once in a career lapse in judgment. Spent 16 years in Superior Court.
I worry about that kind of guidance. I'm not sure what to do with it, because this is a rule 3.8 that was enacted for prosecutors. I mean, I as a respondent as a prosecutor is like baked into the rule.
Actually, I have a suggestion for you. Suggestion is you should reduce the sanction at the very least. That's what you should do. And that's what they did in the other cases. In consideration of the mitigating factors, in consideration for what you, Mr. Gilbertson, pointed out as the very complicated, complex Herculean task. Herculean's a word that's not mine. It came from one of the cases that she was facing. The fact that she's the only one standing here today. We might now sit back in hindsight and say, gee, we don't like that case. We don't think it should have been brought. And maybe that's what ODC thinks. And maybe that's what the hearing committee thinks. But we shouldn't be blaming her for it solely. So that's one mitigating factor. The other mitigating factor is she was forced to resign. I told you about that. Yeah. And third, and I understand the third, and there was evidence of this extensive at the hearing. And the report, I think, gives at least short shrift to this. During the course of the trials, she was subjected, she was subjected to intense harassment, a bomb threat against her family. She was escorted by marshals. I mean, she had children. Again, you're shaking your head, and I appreciate it.
No, I understand.
I'm not going to bang it. So you asked me what you should do. I'm happy to make a humble suggestion. It's been enough. It's been enough. I really appreciate the time that you've given me. I hope you'll be at least half as generous to my more educated colleague.
I can't promise we'll be quite as generous, right?
All right.
So,
well, in any event,
minutes of rebuttal time.
Thank you.
I may hold you to that. In fact, thank you, Mr. Offinger. Mr. Metzler.
Thank you. Jack Metzler for the Office of Disciplinary Counsel. The hearing committee was correct to find that Ms. Kirchhoff violated the special duty of a prosecutor under Rule 3.8E, that she made misrepresentations to the court, engaged in dishonesty, and serious interference with the administration of justice. I'm going to just start right in on the fact that seems to have escaped the attention of in the opening argument, and that is the judge found a Brady violation here. There was a reasonable, neutral decision maker who, at the time, decided, yes, this was a violation. And
Did
the
he
second-
back off of that on reconsideration? I mean,
He did not, Your Honor. I mean, Mr. Gilbertson, forgive me. He did not. If you go ahead and read the reconsideration order that my friend has talked about, and you'll see that in that case, the government was not challenging the Brady violation. They were not challenging the fact that it was intentional. What they didn't like was the suggestion that maybe Ms. Kirchhoff was intentionally lying. And I agree that in that holding, the judge said, I am not making that holding based on the record I have before me. But as you mentioned earlier, that is not the same record that we have here. It's true that that record is part of our record, but it's not the whole record. So, for example, the judge did not know that when he ordered the government to produce a summary of the action camp videos, that Ms. Kirchhoff asked the person who was, well, I guess she prepared her own draft or her own notes, and then went back and said, well, let me edit those before you send them to the judge. And the edits that she made them look less exculpatory. She took out a specific reference that said, if you see violence, report it to the ACLU or maybe to law enforcement. And was that, that description is pretty exculpatory when you're thinking about a prosecution of 200 some defendants, many of whom for which there was no allegations that they personally did anything. The allegation is they joined a conspiracy, and the conspiracy was hatched in these planning meetings. And you know that because we're going to give you one little sliver of a planning meeting that we think shows this intent to riot. And that's why 200 some people have their freedom on the line for a felony conviction. So under those circumstances, yes, it's very exculpatory to know that some of those people or the organization that planned it was training people not to engage in violence, was training them in some circumstances to cooperate with police. So yeah, the judge did not have the entire record on in mind, and moreover, again, if you go back and read that reconsideration order, you will see the judge saying, well, you kept telling me that you were turning over all these things, and I told you, I told the prosecutor that if there are any statements about nonviolence, non-confrontation, I don't have to tell you this because you should know it already, but those obviously have to be included.
to what extent is what Judge Moran saying in this transcript and his Brady ruling evidence of what a reasonable prosecutor, should have known, should have done?
I think those two are on all fours with one another, with each other. So that's just with regard to. There was no backing off of the Brady ruling, and Rule 3.8E and Brady are, as you say in the earlier part of the argument, they are not exactly coextensive. The Rule 3.8 does incorporate the sort of general standard of exculpability, which is evidence that tends to negate the offense or mitigate the offense or negate guilt. But for 3.8, it does not have to be, as it does in Brady, need to be material to the outcome of the case. It's impossible to decide that.
So what does it need to be? I mean, I feel like we're starting to get into kind of a nebulous area. So
Sure.
How do I know if it's information that's going to trigger this duty and trigger, consideration of what a reasonable prosecutor would do? Because otherwise, if it's obviously exculpatory, if I have a record where it's obviously exculpatory, and counsel has pointed us to Haynes for an example of that, although that was hotly disputed in that matter. But if it's exculpatory and then, it's demonstrably true that the respondent knew about the evidence, which was true in Haynes, and it's true here. I don't hear any dispute about that here. How much, wiggle room is left under the remaining factors about, okay, you knew about it, it is exculpatory. What excuse could there be not to disclose it at that point?
So I think the guidance you would take is from the court's previous cases. And what you'll see there is, I think in Dobie, the court was pretty clear about what it means for non-disclosure to be intentional, distinguishing it from basically by accident. I didn't know that that piece of evidence was there. And so when I failed to disclose it, it was an accident. It was not on purpose, and therefore it was not intentional. When it comes to what the prosecutor should whether the prosecutor should reasonably know that the evidence is exculpatory, well, we have a couple of examples of that. And in Hines, I think, is the court declined to impose. They found, well, he really should have known that that impeachment evidence. I think it was in Hines.
Klein or Haynes?
In Klein's. I'm sorry.
Okay.
I said Hines. Is that even a case? But yes, in Klein. So the question was whether he really should have known that that impeachment evidence counted, right? And the court said, well, yes, he should, but he was trained poorly and other things. And so given what he knew, we're not going to impose a sanction. So that would be one way. If the respondent really should have, didn't think that they had to disclose it, but they should have if they had a proper understanding of the law. So that's one way. I think the other way is to look at this is discussed it's either Haynes or Dobie, and I can tell you which. But let's see. So I guess it was in Haynes, because the court said because the respondent had prepared the witness to take the sting out, it said, well, that manifestly shows she knew of the exculpatory value.
But they knew it had sting.
Right. She knew there was sting to take out. So the court then went on to say, well, but maybe she subjectively thought she didn't have to turn it over for other reasons. And it went on to analyze whether those reasons were, or whether those
she had satisfied. She was curious, to what extent, what did he mean by debrief? And, and then she was satisfied with his answer, which turned out to have been.
Right. So of course,
yes, but,
in that case, they're calling upon one thing which I think is pretty much the answer to every argument I saw in the respondents' briefs here, which is that a prosecutor is not allowed to use their own assessment of how material might be explained away or discredited as a justification for withholding it. And I think that
this is where I'm interested. Yeah, I think we may be heading to the same point. What's the role of defense counsel coming into your hearing and testifying?
Right. Well, I mean, I think it is highly relevant evidence as to, just to step back a second, the one question I have about this reasonable prosecutor standard that we've heard a lot from my friend today and in both of their briefs is, if there's any sort of expertise that a prosecutor has, they're going to be more able to identify, because of their experience, evidence or other material that might be exculpatory than, let's say, a layman lawyer or a juror. So it doesn't. There's sort of a disconnect there for me. I don't understand why. If a reasonable prosecutor or a prosecutor would get up and have sort of special reasons to withhold, what all of the cases say is the opposite. The defense's view controls. That's from Vaughn, and it's the role of figuring out what the value is. That's for the defense. So
there's an argument in your briefing about viewing the evidence as a whole and not looking at these separate instances of particular evidence being withheld at a moment in time. And I got to confess, I'm not sure what you're asking us to do or where to go with that? And so I
Sure.
wanted to make sure you had an opportunity to address that here today.
Yeah, and I would like to address it. I think what we mean by that is sometimes you're going to have, I mean, a good example would be, let's say you've got a 2-page document and the first page, if you read it all by itself, like doesn't really contain, not comprehensible enough to understand that its contents are exculpatory. And the same thing with the second page. Second page also by itself looks fine, but when you read them both together, you have the whole narrative, and you understand you understand that there is exculpatory value to the document. And so the reason that we mentioned that in our brief is there are all of these edits to the January 8th video, and some of them you might wonder in isolation, and the hearing committee looked at it this way. So you might wonder in isolation, well, what does it matter that they didn't include the plenary session where they were talking about a whole bunch of different protests, including the ACB march, but also other marches. And so it's not obvious on its face why that one might be exculpatory on its own. Or, for example, you would say they took out the footage of Officer Adelmeyer. And you may say, well, you know, so they often would take out the
Would they take it out or would they just, obscure his face so he couldn't be identified?
I can't really speak to that, but to the extent there is a sort of some other explanation for doing that, I think you have to view it in context of the whole thing, because they had decided this is the officer they were going to use to authenticate the one little part of this video that they wanted to focus on. And the footage that they took out showed that Officer Adelmeyer wasn't really close to that. And so that is directly the Brady evidence that we're talking about. It is impeachment evidence, because he says, I was close enough to hear it. And someone could say, well, look at the video. No, you weren't.
I'm concerned, though, that the approach you're asking us to take, I didn't see much case authority for it, but that was one concern. But the other one was, it starts to, lead us into a situation where, in hindsight, we're trying to make a judgment about whether this prosecutor, whether she was acting reasonably at the time. And we've got the benefit of like taking this, gestalt view of everything that was happening. And I'm not sure, I'm concerned it might be unfair to her Mr. Hoffinger kept talking about her intent. And that's another thing I'm kind of curious. It's like, what is the intent element in these matters?
Well,
I think it's simply the intent not to produce, right?
Sure. Well, the intent, I think, is the intent element in a Rule 3.8E violation is pretty well set out in Dobie, and in that case, it requires basically voluntary conduct, like something you did on
Not the
purpose.
intent to deceive.
It is not the
I
intent
know there's
to
a
deceive.
separate issue in this case about that, but okay.
Right. But with regard to what Ms. Kirchhoff knew or reasonably should have known about these videos or about all of the material, I think the best way to look at it is through the lens of her representations to the court over the course of this prosecution. And you can see in our brief and in the hearing committee findings how she very consistently minimized or misrepresented or evaded, made these statements that made it seem that the government had edited less than it had, produced more than it had, and had a lot less video than it actually had. And that was consistent through a number of hearings. And you could say, well, maybe she didn't understand that one time, but the pattern emerges over time. And when you get to the sort of end of the proceedings, where she is editing out these descriptions, these exculpatory descriptions of the videos that she's been holding on and not telling anybody about for months on end, you reach a conclusion that the hearing committee reached, which is that she was being dishonest. She knew what she was doing during this. And
she did produce a mountain of evidence, didn't she?
She did.
But not this.
But not this. And
Excuse me, counsel.
Yes.
I'm sorry. The reasonable prosecutor standard, since this was a complex case, highly complex case, why shouldn't disciplinary counsel be required to call expert witness, since we need to know another prosecutor in that similar situation, what they would have done? Why shouldn't you be required to produce an expert
Sure.
witness?
Well, so I think we've tried to set this out in our brief, but and I'll do it here too. The idea of a reasonable prosecutor is really a shorthand for the language of the rule, which does not say reasonable prosecutor. The rule is addressed towards prosecutors, yes. And the standard is whether the prosecutor intentionally withheld material that either that is exculpatory, I can give you the full language, and the prosecutor knew or reasonably should have known that it was exculpatory. So it's not that the prosecutor has to be reasonable. This isn't sort of the general reasonable man standard, or reasonable person, I should say, of, what would someone do in this circumstance for a prosecutor? This is given the information that the prosecutor had before them at the time, should they have known that the information tended to undermine the, tended to negate guilt for the crime or mitigate the offense, or was impeachment evidence that could have been used at the trial. And so you don't need a prosecutor to tell you that if you're charging someone with planning to have a violent riot, and if the evidence you're going to use is of a planning meeting, that the other planning meeting where they talk about not being violent and de-escalating and help working with police, that's going to be contrary to the one that, to the evidence that you're using. You don't need a prosecutor to tell you that that if you're going to have an officer sponsor a video, well, the video showing that he's across the room is relevant and is contrary to that.
So why wouldn't her reliance on the judge's instructions, why is that unreasonable?
Well, I've heard a lot about the judge's instructions, but the dump truck order, that had to do with a completely different type of evidence. As I understand it, the government had collected cell phone video. Everyone's taking video with their cell phones. And so there was a lot of video there, but those things were collected from individuals. They had other things on their phone that maybe had nothing to do with this. And so the court was concerned with both, there's a whole big volume of this, and also there were privacy concerns. That's an entirely separate category, and the court's order did not apply to these Project Veritas videos. Moreover, the court held that there wasn't the same sort of privacy concerns. These events were basically public. Anyone could come to the action camp and sign up or attend the, they probably had to learn about it, but they could have attended the meetings, and they didn't have a reasonable expectation of privacy, is what the court said. So those two were entirely different, and there was no instruction not to provide this.
Counsel, does Rule 3.8E, in your view, impose an affirmative duty on prosecutors to pursue or engage in the, quote, pursuit, close quote, of certain categories of evidence?
I believe there's another section of Rule 3.8 that does require that, but I am not prepared on that one. As to whether Rule 3.8E, it is, I don't think that requirement is stated in Rule 3.8E. It is only about producing information that the prosecutor knows or reasonably should know is tends to negate guilt and that standard.
Mr. Tiger, what are you thinking there?
Well, I have what I hope is Rule 3.8E in front of me, and it says intentionally avoid pursuit of evidence or information and so forth and so on,
Okay,
before
so
it
that-
gets to
that I-
the categories.
That I can't answer.
Unless I got the wrong rule, it seems to me the text says that you should not intentionally avoid. Now, all of those of us who practice criminal law are familiar with the ostrich instruction that the government often wants to give. We
If
all
I may,
understand.
if I may, Mr. Tiger, you have the wrong rule.
I do. Oh,
Yeah,
dear.
between the time that this case was these cases were tried and now the rules have been renumbered. So the current rule 3.8D is what we're talking about as rule 3.8E.
Ah, okay. All right.
And
Thank you.
I am vindicated with my hesitancy that was part of a different part of the rule, which it is.
All right.
I did want to mention a couple of things that came up in the first part of the argument. And one is whether the action camp videos were known to the defense counsel. We don't dispute that the defense knew about action camp, but I don't think there's anything in the record to suggest that the defense knew about action camp videos. Certainly not the videos taken by Project
All right.
Veritas. I suppose it's possible because
Okay.
it is part of Project Veritas's MO. They might have posted something like that, but I don't think there's any reason to think that the defense knew
Right.
that the government had.
I do want to invite you to respond to the point that that Mr. Hoffinger made about ODC's failure to, prove up what a reasonable prosecutor would have done, and then that the hearing committee somehow, inappropriately made these rulings without a sufficient record or went beyond the record.
Right. So I think we've talked a bit about what a reasonable or what a prosecutor should reasonably know is Brady material or is material that needs to be disclosed under Rule 3.8E. And I'm happy to do that more if you like. But with regard to, I'm sorry, I lost the second half of the question.
Just what the hearing committee had before it to
right.
make the finding that a reasonable prosecutor
Sure.
would have known to produce it.
Sure. So, I mean, they had the ruling of the judge and they had the testimony of the defense counsel. But what they also had was 2 attorney members of the hearing committee and one public member. A hearing committee this is exactly within the what a hearing committee is competent to do. This is not
One of the hearing committee members was a former Justice Department prosecutor, I understand.
I'll take your word at that. But the underlying point is that hearing committees, this is part of the job. This is not the only rule that has something about what a lawyer should reasonably have known. I believe in the Doby case, there's a footnote that lists them out. The standards of reasonableness are pervasive through the disciplinary system. And these are exactly the questions. So yes, they had the evidence and it was not at all improper for them to make a decision on it. I also wanted to
Mr. Hoffinger, I'm sorry. I can hear you. So that's
right. So I'd like to just move on. We didn't hear a lot about the dishonesty charges. And as I said before, those I think are a pretty good shortcut to understanding whether Ms. Kirchhoff actually knew about the dispositive value of this evidence. And we've laid them out in our brief, but you can see that at times she tells the court they have the exact same video we have, or the only edits that we made were to take out the officer and the videographer. We don't have any other video. I'm telling you this as an officer of the court and statements to that effect. And meanwhile, the court is telling her, as I mentioned before, if there are statements about nonviolence, you have to turn those over. And the court is making other statements to the defense, defending the prosecution's discovery and saying, look, they're telling us they're giving you all the video they have from wherever they got it. And she was in court for that and let it pass and said nothing. Her own witness testified, the officer testified falsely about the extent of the edits, I believe, and she allowed that to go uncorrected. And when she was asked about Project Veritas and said, the court said, well, did you ever tell them what was the nature of this organization? She said, well, nobody ever asked. I mean, that was just false. That was a lie. The defense had asked her soon after she produced these videos. They said they look like they're edited. Where do these come from? Who gave them to you? And she didn't provide that information. I wanted to touch briefly on Project Veritas, because there's a disagreement in the hearing committee. The hearing committee chair thought the identity of Project Veritas was not exculpatory information, and the majority felt otherwise. Project Veritas is well known for taking undercover videos, manipulating them, and
Was
putting
there
them.
any evidence that that had happened here?
Well, no, I don't think there is. But nevertheless, the origin of the video is relevant to the weight of the evidence, the weight that the jury would give this evidence. It would give them some reason to question, are we seeing the whole thing? Is this an accurate depiction? And in fact, it had been edited. It just hadn't been edited by Project Veritas, as far as we know.
What did you make of the dissent and the point about, excising the tail end of that video and, therefore missing this upper echelon comment? She testified that she wasn't aware that that was on the tape.
Right. So the hearing committee found that it's hard to understand exactly what their finding is. Either she didn't know there was anything at the end of the tape, or maybe she didn't know that it was removed. As we have argued, neither one of those is really supported by the evidence. Her testimony in this case and her contemporaneous statements to the court was that she knew, was that she didn't understand, or let's see, I want to get this right, was that she thought she had only cut off the very end of the tape. So that's not saying I didn't even know anything was missing. I didn't know anything was there. She thought they cut off something. And so then the question is, if she knew there was some material and she knew that it was cut off, then the question is, was it reasonable for her to believe that was not exculpatory, to not watch to the end? And I think given the fact that it was excised, and it was the only edit that was made to that segment of the tape. So somebody loaded up that video and said, this 2 minutes, we're going to get rid of it. The idea that you can do that without looking at it, I submit, is just not reasonable.
But the hearing committee found what it did.
Well, that's
Right?
why I say it was
So
not.
now I don't know
Well, so
what we can do about that.
what you could do is you could say it's not supported by substantial evidence. And we've laid it out in our brief,
right.
because her testimony was, I did cut off something. And then it's up to, and if you agree that it is, I'm happy to talk about why it is exculpatory, but the hearing committee and the judge, I don't think, had any problem finding that. But the question then is, if she knew that this segment existed, was it reasonable for her to lack knowledge that it was exculpatory? And if you believe her that she didn't, and you probably have to believe.
Talk to us about sanction a little bit. And I know we have a prosecutor as a respondent when we're arguing about whether a 3-month suspension is unduly harsh.
Well, I think your comment acknowledges the reality in the last few cases that the court has declined to enter a served suspension in any of these cases. But I think,
what a civil lawyer, what kind of sanction would he or she be facing for similar conduct?
well, I think if you look at the dishonesty alone, making affirmative misrepresentations to the court, 8.4C and 8.4D, I think you would wind up with a suspension of, on the order of the suspension we're talking about here, 3 months or 6 months, something like that, just for those violations alone. What's
But
different?
this is a rule that's about prosecutors, and I think that that plays an important role in the analysis. But
Well, I think I agree with you in that we look to prior cases, and the court has a mandate for uniformity that it talks about. And so I think that it's necessary to fit the sanction within those, how the court has discussed it in prior cases. Now, if you use that, if you take that analysis seriously, then we need to take the court at its word. And in the Dobie case, the court explained exactly its reasoning. It said, look, the serious of this conduct is very serious. It's hard to discover. It can have serious outcomes and effects on innocent people. And in this case, I think worse than the other two, because we had 200 some people who were, again, on trial for felony charges. I mean, that's not nothing.
Well, the dissent in Dobie, I gotta say, is fairly persuasive, and yet the court doesn't seem to be going in the direction that the dissent sees as the clear path.
I mean, I agree with you, but I think we also have to take the court at its word. And what the court said is 6 months is a suspension that reflects the seriousness of the offense. But in Dobie, we don't think these particular prosecutors were responsible for these decisions. They got really some bad advice from their supervisors. And
Do we have anything in the record in this case that suggests that might also be true of Ms. Kirchhoff? That there's like express evidence in there that shows her getting direction from above about not making the disclosures that are challenged here.
There's nothing that's similar to Dobie, where say went up and said, "Here's our question,"
or Haynes for that matter.
Or Haynes for that matter.
Ms. Haynes had some decent evidence along those lines.
Right, and I think in Haynes it was discussed as an honest mistake. Well, this was not an honest mistake. This was a mistake that is combined with dishonesty, and what the hearing committee called pervasive dishonesty. So. Again, I agree. We don't have a case in which we have a served suspension for a prosecutor under this rule, but we do have lots of cases with served suspensions for dishonesty, and the cases that we do have all explain the mitigating circumstances why the court elected not to require those prosecutors to serve their suspensions. Those mitigating circumstances are not present here. The mitigating circumstances that you heard about. This is a tough case. I produced a lot of discovery. I've had bad things happen to me. Those are unfortunate. And I would not wish on Ms. Kirchhoff to have, people bullying her and so forth. Oh, I am also to mention that there was an attorney who was disbarred for conduct that included, his name was Howes, Howes. For conduct that included a 3.8E violation. But I think in this case, what we really need to focus on is how the court has approached the sanction in these recent cases. And while it hasn't actually entered a served suspension, everything it has said suggests that this is the type of case where you would.
Excuse me, counsel.
Mhm.
Respondent testified that her view of her disclosure obligations were based on what her supervisors told her. So why would that not be a mitigating factor that we should consider in order order a sentence of less, not a sentence, a sanction of less than 6 months?
So I think the answer to that is in your question from earlier, which is we don't have any findings about that. There was no finding that, I think there's a finding that the decision to charge these defendants in a single indictment and for conspiracy was at the advice of Ms. Kirchhoff. There's a finding that she was the lead prosecutor and she was responsible for these decisions. There are not any findings, and they have not suggested any. They sort of hint at the idea, and they cite testimony somewhere, but they don't even make the argument that the hearing committee should have made a finding about the supervisors, and I submit that it would be inappropriate for the board to search the record and sort of make findings on its own in that circumstance. So the answer is those facts are not before the board.
What do you make about the argument about the uncharged conduct that the hearing committee report recited at one point? And they expressly said it was not, part of their decision. They weren't relying on it.
So
Is it relevant to sanction?
yeah, I'm glad you bring that up because I was going to start with that because my friend said, well, he's sort of confused by that section, and I was sort of confused too because it's hard to really tell what's the dishonesty that they're talking about. They cite this that statement that I referred to earlier, where Ms. Kirchhoff, toward the end, as in the various trials, this information is starting to come out. When she makes this, she says, "Look, I'm an officer of the court, and I'm telling you, we have nothing else. We've given them everything. There's no more edits. There's nothing." They quote that. Well, and they say this is uncharged. Like they say that is completely misleading, but this was not charged, so we don't want to rely on it. Well, that's in our specification of charges. It's in that exact quote is in our specification of charges. That quote is in our it's in our post-hearing brief, and we argued that was dishonest. So I don't know why they chose to say that was uncharged.
I'm curious how you view what your duty is to is it your duty to lay out, to plead with specificity
Right.
every instance of conduct that you think supports the charge? Or is
So,
it,
I mean, I think,
I know it's not Gibson pleading, but go ahead.
Yeah, so under Rule 11, our responsibility is to basically make the charges clear enough that the respondent can understand what they're being charged with and effectively respond. And as to the materials or the facts that are discussed in that part of the hearing committees, those were definitely before. I mean, like I say, it's in the specifications.
Okay, but even if it wasn't, I'm
Yeah,
really interested in the answer to this. If in the course of the hearing, though, there's evidence that's developed and comes out that's consistent with the charges, what is that uncharged conduct that can't be considered? Or
I think it's not actually. So one example would be, I think I heard as an earlier part of the discussion something, or maybe I read it as I was preparing. There are like a couple of things that happened in the trial that are very consistent with with what we're talking about. Other statements by I think it's in our post-hearing brief, to be honest. But I didn't mention it in my brief here. And these are statements from the court or statements from Ms. Kirchhoff about, what sort of things should be and what should be turned over and what the government had or hadn't turned over. And I thought, well, should I bring that up to the board at the argument? Because that's a good one too. And I decided not to, but I think it would have been okay if I did, because the fact is she's charged with dishonesty. We listed a bunch of places and the hearing committee found a bunch that were dishonest or misleading. And if there's another statement, or a good example would be, suppose we charge the ultimate statement, the conclusion of the paragraph, and the hearing committee or the board likes the entire paragraph and thinks that better illustrates the dishonesty. I think there's nothing wrong with finding dishonesty based on the full record they certainly had notice of. And if there are no further questions,
well, let's find out. Dr. Hindle?
No, I have no.
All right. And Ms. Rice Hicks?
Nothing further.
Ms. Spiegel?
No, nothing this time.
All right.
okay, then I'll just say one last thing, because that's the order of the day. With regard to the dishonesty and the substantial interference with the administration of justice, the 8.4D basically follows on from the 3.8. So I won't talk about that. But I will note that there wasn't really much or any argument with regard to the dishonesty found by the hearing committee in the opening or the reply brief, other than to say, well, the judge later said he didn't think on the record that he had before him that there was that she had been intentionally trying to conceal evidence. And And the answer to that is, again, the record, this record, the one that the hearing committee had, in which they had the opportunity to hear from Ms. Kirchhoff and evaluate her testimony. That's the record upon which the findings of dishonesty were made. And to the extent that the hearing committee did not believe what she had to say, and I think it's evident that it didn't in a lot of respects, those are credibility findings that are subject to the Crane standard and so forth that the board is well familiar with.
Carolyn, did you have any other questions?
No,
Okay.
not at this time.
All right, Mr.
Thank you.
Metzer, thank you.
Thank you.
And counsel, as you approach the podium, I just will point out, we've been going here for about an hour and a half. So I think that the 12 minutes that you have been reserved, I'm going to ask you to stick to that to the extent you can.
Of course. Thank you. Thank you, Mr. Chairman. It's not possible to address all of the myriad of issues and arguments and questions that have come up in the limited time I have. I'll try to address some. I'm sure there will be things that I'll have forgotten, and I'll go home and I'll go, should have talked about that as well.
Well, the briefs have
But I
been
appreciate
great from both sides. So go ahead.
So where to start? I'd like to start with one of the questions that Ms. Hicks raised, and I think you addressed it earlier as well. What kind of evidence should we expect ODC to put on when the real question I submit that was key to the committee's decision and is the key to looking at what we do here is, was it reasonable for Ms. Kirchhoff to believe that what she did not turn over was not Brady, that she didn't have to turn it over? Judge Knowles, Judge Morin, Judge Leibovitz, I think generally all found she didn't intend to commit a Brady violation, meaning
So no matter how exculpatory it was, she thought she already had the nod or had a license not to produce it.
Correct.
Based on prior directions, rulings from the bench.
Correct. And so the committee findings had to do with, they didn't think it was reasonable that she didn't turn it over. Not that she intentionally committed a Brady violation. She intentionally didn't turn it over, but she didn't believe it was Brady. And so as we pointed out, there really was no evidence before the committee as to what a reasonable prosecutor would do, or to slightly turn the phrase that Mr. Metzler was talking about, if you look at the language in the rule, should this prosecutor have reasonably known that she should have turned it over? The facts here are not like Haynes. I know I'm jumping around. They're not like Haynes. They're not like Doby. They're not like Klein, meaning you're talking about impeachment of the key government witness that convicted someone and they went to jail for 60 years. These people, none of the 200, I know they like to say, oh, there's damage because of volume. No one was convicted, right? And but that's a side issue. So the point is, the factual posture of what Ms. Kirchhoff was looking at was not simple, like I would submit was present in those other examples of key impeachment evidence of the key witness. These were complex, subtle issues. At least she believed so. And so, again, none of the judges found that it was intentional. And Judge Morin, none of the judges, and specifically Judge Morin, no one was ever asked and no one ever addressed whether they thought it was unreasonable for her to not turn it over. They said, you should have turned it over, but I didn't find it was intentional. No one went to the next step, and the bar rules are there, they're plain. No one was asked to address, hey, should she have known?
Right. It's not the same test.
And they knew that, and they had ample opportunity, as Mr. Hoffinger pointed out. All of the witnesses they put on their witness list, all of the government prosecutors. You don't have to have a prosecutor to testify. I know you raised the question, I think Mr. Gilbertson earlier, well, isn't Judge Morin enough? Judge Morin, you know, that begs the question, well, then do we have to have an expert or do we not? I would say, I wouldn't want to say there is not an example of exculpatory evidence that you go, everybody knows that's exculpatory. You know, look at Doby, Klein, and Haynes, where you're talking about impeachment of a key witness. I think it'd be hard to argue that that kind of material wasn't exculpatory. But again,
Counsel.
yes, ma'am, I'm sorry.
In this case, the defendants were charged with conspiracy for
Yes.
participating in this violent act.
I'm glad you asked that question. Go ahead. Sorry.
So that's okay. So the evidence of nonviolence would not be exculpatory.
Let me the short answer is, I would say no, but I understand how the committee found, and I understand, to me, our key issue is, well, should she have known? Let me read you what Judge Leibovitz said, and it's in page 13 of our reply. Judge Leibovitz ruled that evidence to include videos of the defendants attending events other than ACB, right, the anti-capitalist bloc march, was not relevant. Judge Leibovitz said, you could play the inauguration too. You could play, his visit to the beer garden or Georgia Avenue and Park Road, but none of that would necessarily be relevant to this particular event, the January 20 riot, and his intentions. I'm not going to allow you to play videotapes of other events. I don't think that playing all of the other things he did while he was here was relevant to what his purpose was in being out there that day. And so when I know a number of you have raised the point of this is a conspiracy, doesn't that give a broader Brady obligation? I would say generally yes. By the way, most of us are all longtime former prosecutors. Committee Chair Rosenzweig and I were colleagues together. So we're all very familiar, I'd say, with this topic. I got off topic. So when Judge Leibovitz said that we're not going to allow you to go astray, the conspiracy charge was very tailored and very specific, and not simply Ms. Kirchhoff's idea. It's offensive to sit there and say this was all her decision. She was in charge of everything. On such an important, significant case, whether you agree with the decision to prosecute or not, and hindsight's a great benefit, or should we have spent the time and effort to do that? But it's ridiculous to suggest these were her decisions to charge and to pursue this case without consultation and approval from the highest levels of the U.S. Attorney's Office. The conspiracy was very narrow. The conspiracy was on the day of the riot, you had a march that started, and at some point during the march, it turned into a riot. And the conspiracy alleged that the conspiracy began on that day during the march and ended at the time of what they called, they didn't say corral, I think they called kettling the ones that couldn't escape, right? So it was a very short conspiracy. It was a very narrow conspiracy and substantive charge that had to do with people that were marching along. And once the riot began, they decided to participate in the riot. That was the nature of the charge and the conspiracy. And so I think Judge Leibovitz's comments, whether we agree or not in hindsight's a great leveler. But in the heat of the moment case, when you look at the evidence that was submitted before the committee and the testimony of Ms. Kirchhoff, both before the court and before the committee, about all the things she had to do to try to do discovery. And I disagree with counsel when they say, oh, dump trucking had only to do with the police body cam. She certainly didn't take it that way, because remember, she said, I'm very concerned about being in a Brady trick bag. She's basically being pilloried for doing her job where the government, where the court says, just don't give them everything. I want you to be specific and look through it and make a decision. What's Rule 16, right, that I have to turn over? And what is Brady? So, boy, if I had the luxury, I'd say, no disrespect, Judge. Hate it when you say no disrespect, right? Because you mean it. I'm going to give him everything. But the judge specifically directed her not to do that. And so I disagree with the suggestion that somehow that mindset of being directed to be specific about what you give didn't play a part in Ms. Kirchhoff's decision-making about the action camp videos. And so,
But those weren't burdensome, right?
they weren't.
The action camp
burdensome.
videos weren't a dump truck of material.
No, the dump truck had to do with all of the evidence in the case.
The cell phone videos,
Certainly, sorry, Your Honor. Sorry.
just the cell phone videos, that was the dump truck issue.
I don't think, maybe that was the context of the discussion, but she took it to mean I can't just turn over everything. I have to look specifically, and she did. So I go back to she's being put through this because at least it appears to me, ODC was very offended by the case that was brought and very offended that the U.S. Attorney's Office pursued this case. And so it's replete.
Get that.
It's
Pick
replete.
up on that at all. I mean, I know you folks, that's in your brief, and you thought that the hearing committee said something to that same effect. But, the hearing committee cited the charging decision as a mitigation in favor of Ms. Kirchhoff, that she was handed this large matter
Yes.
that involved these conspiracy counts and that it was a lot to manage. That's the way I took it.
And
So I don't think anyone's really trying to criticize her for the charging decision, but I think that it's the impact that the charging decision had on the universe of evidence that might be exculpatory. And that's where I see that being cited in the case, not as criticism of her or even that office.
Understood. I wasn't suggesting the committee felt that way. I just think there was, well, I'll move on. And I know I'm out of time. If I may chat a little bit, chat's the wrong word. If I may speak a little bit and address questions if you have them. And so before I forget, because I know time is limited, I do want to also address the sanction discussion. And I do think it's helpful just as a quick reminder. In this case, the committee has recommended a 3-month suspension. ODC has recommended a 6-month suspension. In Hames, which is the Chandra Levy case, right, which we're talking about, the key cooperation witness was a jailhouse snitch, and they didn't turn. I mean, it is the key witness. It's the only witness that says he confessed to the murder, and he got 60 years in jail. And in that situation, the committee recommended 90 days. The board recommended 60 days. The Court of Appeals stayed the suspension and imposed a 1-year probation. And Klein was the one where the victim who was shot says, I couldn't see, I forgot the exact phrase. I don't know who shot me. I think it was, I don't know who shot me. They didn't turn that over. I mean, it's impeachment. And in that situation, it was the board recommended a 30-day suspension. And in that case, the Court of Appeals imposed no sanction whatsoever. And Dobie was the District of Columbia Department of Corrections officer, Childs. And Childs lied about macing somebody who he said was unrestrained. It turned out he was restrained. There were all kinds of problems with the impeachment of Mr. Childs. And it actually went to the Lewis Committee at the U.S. Attorney's Office to even call Childs as a witness. You know, it's that much of an issue. That was the Collins report. And in that situation, the board recommended 6 months suspension, and the Court of Appeals stayed the suspension and put it in a 1-year probation. I respectfully submit that the facts here that Ms. Kirchhoff was struggling with about whether to disclose, in addition to everything else she disclosed, were more subtle, more complicated, and at least from her perspective, and certainly credited by the court and credited by the committee, because the committee is basically saying, we believe a reasonable prosecutor would have turned it over. They didn't find her liable because she, you know, they didn't find she intentionally didn't turn over something she absolutely knew was Brady. So I go back to, shoot, I lost my train of thought on that one. We were talking about, was it reasonable for her? Oh, I know what it was. So these facts were much more complicated. Project Veritas, for example, I know Mr. Tiger asked about the rule of completeness and 404B evidence. I believe Mr. Borchert, who was in AUSA, and Mr. Tishner, the supervisor, both concluded properly that the identity of the Project Veritas videographer wasn't something that needed to be disclosed. And so I think there was a question asked about, well, wasn't there at least some reliance on supervisors and colleagues, and at least with Project Veritas? I think that was an easy one. I think that one's an easy one, that she thought, we're not gonna sponsor this video from Project Veritas. And counsel's explanation or suggestion of how that could be useful, as we put in our brief, that's basically calling for speculation, calling for just really rife argument before the jury to prejudice the jury, where it's not particularly relevant who recorded the tape if the tape has been otherwise authenticated by an independent person.
But it turned out to be relevant. I mean, that's like a real world example, because once it was disclosed that it was Matt from Project Veritas, right? The defense counsel was allowed to interview him, and that's how they learned about the action camp videos. So
the action camp videos, to be clear, counsel called that a planning meeting. The planning meeting and the action camp videos are two totally distinct things, as I think Judge Leibovitz's comment that I read to you showed. The planning meeting, so I think that's the upper echelon area. Those were the people from J20 that apparently were planning the riot. That's totally different. Edelmeyer was undercover there, and that was disclosed with certain edits. The one edit that was criticized by counsel was that she didn't look at the rest of the tape. If you, and I do it,
All right, so what was Action Camp?
Action Camp was a community free.
Adelmeyer was there as well, right?
Pardon?
Adelmeyer was also at some of those, wasn't he?
Yes, he was. And so,
And so was Project Veritas,
Yeah.
so
and I think they turned over the notes.
it's
Hindsight,
interesting to them.
I agree, it would be easy to say, should have turned them over. But the question is, were the Action Camp videos, which council likes to talk about and go, well, they were encouraging nonviolent activity. The nonviolent activity, as we pointed out, was, well, if someone's kicking a dog, how to de-escalate that, right? If you have
An
two people,
example, I guess. But
Yes.
They were talking about de-escalation techniques and for what?
but
For
I don't,
Inauguration Day activities and marches.
and I respectfully do not understand how you can go from that to say that is admissible in the riot charge where you've
The
cabin,
conspiracy charge where the planning conduct is the issue. For some of these defendants, for which there's
got-
no evidence that they themselves committed any violence.
and they had the planning video, albeit not all of it. What was left out was after I think Matt from Veritas walked out and was talking to somebody and she had thought, she being Mrs. Kirchhoff, thought that the recording had ended, that there wasn't anything beyond that. What it was Matt talking to someone else, wasn't the recording of the event.
Seems like both sides want us to view the evidence in its entirety.
Yeah, so if I may, again, I know you've been very gracious in your time. I'll, to
Just go ahead and
summarize-
wrap it up. That'd be great.
Yes, to summarize our position, Ms. Kirchhoff did not intentionally withhold Brady. The question that I submit is most important here, putting the sanctions aside, was her conduct reasonable, and did ODC put in sufficient evidence to address that conduct? The only person who testified that she believed it was reasonable was Ms. Kirchhoff. No one testified that it was unreasonable for her to have not turned it over. The defense attorney said, I would like to have had it. It'd be beneficial. I could hammer the other side. I disagree whether it would come in, but that didn't address the issue of whether she should have known to give it to us. And that was respectfully never addressed. And this isn't the kind of evidence, unlike the other cases, that's so obvious. And so ODC needed to do more. They needed to bridge that gap and not leave it to speculation, and not leave it to just the board's experience of, well, I was a prosecutor. Yeah, I think that would be Brady. That really invites a problem in how we conduct these hearings and their burden to actually put in evidence that we can then discuss on appeal. But to simply go, well, the committee members had a good feel for whether that was Brady. I know they didn't use those exact words. So unless there are any other questions, again, thank you for letting me go over my 12 minutes.
Thank you, counsel.
Thank you.
And we will deem this matter submitted. And I thank you all. Again, I think I speak for the entire board that the briefs to the board are outstanding for both sides, and certainly the argument today. And I appreciate your time.